Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is from our Curious Lawyer series and is a look at how the law intersects with us as we go to rock concerts. If we take the act of going to a concert and ponder the myriad contract and copyright issues that lurk in that fun 2-hour event, we can get a great overview of some copyright fundamentals from the music space that are intersecting that experience in ways we may not even realize. This program allows us to take the simple act of going to a concert and look at the various stages of a concert and break them down from a copyright perspective. And along the way, you will hear about some artists and bands, from Sir Mix-a-Lot to Green Day to Nina Simone. So I hope you sit back and enjoy the program. And don't worry, none of this will spoil the enjoyment you have when seeing your favorite rock band or singer at a concert. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law, where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program, where you will see fascinating legal topics related to the CIA secrecy and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that in fact has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our exploration of how legal systems can be weaponized and how a lawsuit can turn into an example of persecution by prosecution. Let's start with a brief overview of the legal topics we will be addressing today as you take your journey to a concert. Broadly, they fall into 2 camps, some contract law, and then more pointedly a variety of copyright law issues. That's it. No complex antitrust issues, no criminal law, just plain old contract and copyright law, and rock and roll, of course. If we double-click on this a bit, here is where we are going on our journey to the concert. First, some brief contract issues. After all, we arrive at the concert and park our car in the venue's parking lot. That itself triggers some contract and bailment legal issues about who is responsible for damage or loss in the parking lot. Of course, there are also a host of contract and arguable antitrust issues that circle around the very act of buying the tickets. But that is outside this program's scope, and indeed, given the antitrust issues in litigation today over the primary and secondary ticket markets, that it itself its own program for another day. Suffice it to say, for today, you bought your ticket, no doubt for a lot, and are excited to see the musical performance. Second, once we get to the concert, we will dive into some copyright issues that touch on public performance of music. Within copyright law, this lets us look at the public performance, right? Specifically, how do venues play music out loud? How do they play background music in the venue, the hotel lobby, or the bar you sit at? This will get us into the performing rights organizations and the licensing scheme that exists for public performances of music. We will also look at the right to make cover versions of other artists' songs. Specifically, how does an artist cover another artist's song at the concert or on a subsequent CD they sell? This gets us into limits on the exclusive copyright interests and a compulsory licensing scheme that exists and attaches to music once created and published. And of course, when you are at the concert, there is a whole stage and scenery at the concert, which allows us to explore some copyright fair use issues. This will take us to a famous case involving the rock band Green Day and their audio-visual artwork displayed during one of their concerts. We will look at an aggrieved artist whose work was modified and used in a video at the Green Day concert, and whether Green Day's modification and use of his work was an act of copyright infringement, or whether it was fair use within our copyright laws. And we also will touch on that background music you hear before the show begins. Lots of great anthems and songs are played pre-show. How is that done? Is it lawful? What are the rights and rules related to that performance of that music at public venues? Now, you also, of course, are so excited to see your favorite band, and you, like everyone it seems, take out your phone and record your favorite song being performed. You then post it to your social media account to share with the world. What infringement issues does that trigger? Are you now a copyright infringer? All these questions and more will be answered, so let's get going. Let's start in the beginning, and this brings us to a quick exploration of contract law and how it intersects with the parking structures we park in at concert venues. So, you arrive at the venue, you pull up to the parking gate, you push the button, and you get a parking ticket with a whole bunch of pre-printed language on the back of the ticket. You then park. Already, contract law has touched what we are doing, and there are a couple of different areas of contract law involved in this. In some jurisdictions, a bailment situation is created at the point of entry. Under a bailment scenario, you as the person parking are the bailer, and the parking structure is the bailee. In these jurisdictions, the bailee has a duty to provide reasonable security to protect the car and keep the premises safe, and it is their burden so that if something happens, they bear the burden of proof. This is ideal for you as a potential plaintiff if something happens, as the burden of proof is often shifted as a result of bailment legal structures. Now, in some jurisdictions, there will not be a bailment relationship if the ticket and the other postings indicate that the act of parking does not create a bailment relationship. That disclaimer is not enforceable in all jurisdictions, but it is in some. Of course, even if there is no bailment relationship, general negligence law will apply. This means if something happens, the burden is now on you as the plaintiff to prove negligence in the lack of security to protect your car or its belongings. And of course, you look at that ticket before you put it on your dashboard. You notice that on the back of it, there is a disclaimer of liability for anything that could happen to you or your car. Is that enforceable? They are often unenforceable as blanket waivers. This is an important contract issue that we experience every day and may give little thought to. What happens when we take that ticket and enter? What rights do we retain? What rights do we lose? So let's start by taking a look at a couple of cases to explore the negligence standards in parking structures as they apply to your car and even your personal safety. The first case we will look at is from California and is Gardner versus Downtown Porsche and Audi. It is reported at 180 Cal App 3rd 713 from 1986. Here are the basic facts of what happened and the holding. The plaintiff's car was stolen while in defendant's care. Defendant conceded it was negligent, but claimed that plaintiff signed a form repair order. Now that form repair sheet contained a disclaimer for liability for theft. Therefore, the defendant argued that it was not liable for failure to exercise due care. The Court of Appeals found that the attempted exemption from liability was against public policy and thus ineffective to excuse any negligence. The court reasoned that under California Civil Code Section 1668, an automobile repair garage could not exempt itself from liability even for ordinary negligence if the service it provided implicated the public interest. That California Code section is a fairly standard law from many jurisdictions. It specifically provides that, quote, all contracts which have for their object, directly or indirectly, to exempt anyone from responsibility for his own fraud or willful injury to the person or property of another or violation of law, whether willful or negligent, are against the policy of the law. End quote. Thus, attempts at contract language to disclaim liability for negligence in the performance of the contractual services was not viable. So, if the parking lot leaves the gates open and lets anyone in to rob cars without any security, you will have recourse under negligence law. But now let's look at another side of that coin in a far more serious scenario, one where negligence is asserted, but ultimately not proven due to causation complexities. This brings us to the case of Leslie G. versus Perry. It is reported at 43 KLAP 4th 472 and is from 1996. In this case, a woman was sexually assaulted in the parking garage of her apartment building. She sued the building's owners, contending they were negligent because they failed to repair a broken security gate, and that their negligence caused her assault. But the trial court granted the owner's motion for summary judgment. The Court of Appeals affirmed because there was no direct evidence either that the rapist entered or departed through the broken gate, or that the broken gate was the only way that he could have entered or departed. Thus, the court held that the plaintiff could not survive summary judgment simply because it was possible that he might have entered through the broken gate. This case shows how parking garage liability may stand, but how hard causation proof standards can be to establish that any specific negligent act was the but for cause of the injury. So now that we have walked down a little contract law review in this concert escapade, let's move to copyright law, the central area of our exploration today. This requires us to start with some copyright basics, a quick overview for you of the fundamentals to copyright law and how it addresses specifically music. Let's start in the beginning. Copyright protects original works of expression that are fixed in a tangible medium. Those are dual requirements for copyright to then attach to the creative work. Let's take the very first requirement, known as originality. It simply means that the creation is original to the author. This is not a requirement of something that is new and novel and never before seen. It simply means that it is the original creation of the author at issue. The bar for originality is very low. It essentially means that there must be the most minimal creativity and copyright will attach. For example, if you are watching this and doodling a pretty cool doodle on a piece of paper, you are creating a copyrighted work in this moment. Why? Because it is an original work of expression made by you, and it is also being fixed and in a tangible medium, specifically the pen to paper. But before we get to the fixation requirement, let's talk a little bit more about how courts approach the originality requirement. Courts generally do not want to get involved in making any kind of artistic determination about the artistic merit of a creative work. This is a long-standing policy in copyright law which goes back over a century to the Supreme Court. It is indeed a fundamental bedrock principle of copyright law today. The rationale for this rule was expressed long ago by the Supreme Court, when it indicated that courts will not wade into artistic determinations because they are not equipped, and will, on one end, deny protection to things that are artistic, and on the other end, give protection to things that may not be sufficient. This is what Justice Holmes said at the turn of the last century in the early 1900s. Quote, "At the one extreme, some works of genius would be sure to miss appreciation. Their very novelty would make them repulsive until the public had learned the new language in which their author spoke. It may be more than doubted, for instance, whether the etchings of Goya or the paintings of Manet would have been sure of protection when seen for the first time. At the other end, copyright would be denied to pictures which appealed to a public less educated than the judge. Yet if they command the interest of any public, they have a commercial value. It would be bold to say that they have not an aesthetic and educational value, and the taste of any public is not to be treated with contempt." End quote. Another underlying theme is that when it comes to creative works, very few things in the most abstract sense are truly new. Here is another quote from Justice Story, quote, "In truth, in literature, in science, and in art, there are, and can be few, if any, things which, in an abstract sense, are strictly new and original throughout. Every book in literature, science, and art borrows and must necessarily borrow, and use much which was well known and used before." End quote. These are two fundamental pole stars that frame the originality inquiry. So yes, your doodle is being protected right now. This brings us back to the fixation requirement. The copyright code's language is that it must be fixed in a tangible medium, which is legal language that means it must be recorded in some permanent fashion. This means pen to paper, oil on canvas, typing on a keyboard into the memory of the computer, or molding a piece of clay into a sculpture. What it also means is that if you come up with a fantastic little love poem and hire one of those skywriting airplanes to put it in smoke in the air for your loved one, you have not fixed it any permanent form, at least in that fashion. And today there is no registration requirement to have a copyright. It exists at the moment of creation. But to sue for infringement, you do have to register. And registering before a work is infringed gets you access to powerful statutory damages remedies. Specifically, if your client timely registers, then they can get statutory damages of up to $150,000 for an infringement if it was done willfully. This is a powerful remedy that is divorced from actual market harm or damage, and so is a very powerful weapon that makes registering very valuable. So as a practice pointer, it is good to advise your clients who are creating works to register the copyright upon creation or publication. This brings us to the question of what types of works fall within the realm of copyright. Copyright protects books and other writings, music, of course, which we will be talking about today, movies and films, photographs, artwork, software, and source code, even architectural works and clothing, designs, as well as pantomimes, choreographs, and plays. This is just an illustrative list and is not exhaustive. What it does not protect is ideas, and the line between ideas and expression is very important in copyright law. Copyright law protects a given expression, but not the underlying idea. In other words, when Einstein developed his special theory of relativity, the paper he wrote would be copyright protected. But the idea of E equals mc squared or the idea of special relativity would not be protected. Other people can write and discuss that theory. The question would be whether, in so writing, they actually copied his expression of that underlying set of ideas, or if they wrote their own original expression. This idea-expression line is a critical fault line in copyright, and courts will inquire as to whether the work at issue is really expression or just an idea. This is because under the Copyright Code, specifically Section 102B, no, quote, idea, procedure, process, system, method of operation, concept, principle, or discovery, end quote, is subject to copyright protection. In other words, copyright law is not going to allow one to monopolize ideas, systems, or other discoveries. The idea sounds simple in articulation, but often in practice it can be very thorny. Here is a great quick example of the line from a Ninth Circuit case involving a yoga practice. A plaintiff, Bikram Yoga, claimed a copyright in a series of 26 yoga steps and poses performed during the yoga workout. A defendant used the same or a very similar set of the 26 steps in their yoga studio, called Evolution Yoga, offering hot yoga. Plaintiff was unhappy and sued, claiming copyright infringement. The Ninth Circuit held that the 26-step sequence described in plaintiff's book was not protectable against others using and teaching it because it was a health-based sequence and process. And, at root, it failed the idea expression line because it was an idea that cannot find copyright protection. In other words, the yoga sequence was the idea at issue, not the expression of an idea. Thus, as with the Einstein example I gave you earlier, any copyright in Bikram's book did not extend to the actual sequence itself because that was an idea and process or system. Copying his book's actual language and images could be unlawful, but copying the 26 poses in a yoga studio is not an act of infringement. This is an excellent and important case to illuminate the line between idea and expression that we have discussed. If you want to read the full case, which is fun and excellent for an overview of these issues, you can find it from the Ninth Circuit in 2015, case number 13-55763. So you now have a copyright, but what does that mean exactly? What are the exclusive set of rights you have? This is answered by federal copyright law again, and as a side note, federal law is the exclusive depository of laws that relate to copyrights, and it preempts state laws in this area. So let's look at the exclusive rights that you as a creator or author have under federal copyright law. There are several specific ones you see listed here as the exclusive rights to do and to authorize any of the following. 1. To reproduce the copyrighted work in copies or phonorecords. In simple terms, this means to make copies of something, such as photocopying or cutting and pasting or downloading. 2. To prepare derivative works based upon the copyrighted work. In simple terms, this means to make new works from the original. Think the James Bond novels, or when George Lucas made Star Wars, he had the right to make sequels, prequels, and other works based on Star Wars. 3. To distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending. 4. In the case of literary, musical, dramatic, and choreographic works, pantomimes and motion pictures and other audiovisual works, to perform the copyrighted work publicly. 5. In the case of literary, musical, dramatic, and choreographic works, pantomimes, and pictorial, graphic, or sculptural works, including the individual images of a motion picture or other audiovisual work, to display the copyrighted work publicly. 6. In the case of sound recordings, to perform the copyrighted work publicly by means of a digital audio transmission. These are the codified exclusive rights. What happens, however, if the exclusive rights are tripped? This is what is called copyright infringement. To assess whether there is copyright infringement, courts employ a two-part test known as the substantial similarity test. It varies slightly by circuit, but here is the Ninth Circuit's formulation. As the Ninth Circuit held in Antonick versus Electronic Arts at 841 F. 3rd 1062 from 2016, the court employs a two-part test for determining whether one work is substantially similar to another. Specifically, a plaintiff must prove both substantial similarity under the extrinsic test and substantial similarity under the intrinsic test. The extrinsic test is an objective comparison of specific expressive elements. The intrinsic test is a subjective comparison that focuses on whether the ordinary reasonable audience would find the works substantially similar in the total concept and feel of the works. Now, the extrinsic test is one of law for the court, so is often adjudicated on a motion to dismiss or summary judgment motion. If a plaintiff survives that gauntlet, then the jury will decide it as well as the intrinsic test. Within the intrinsic and extrinsic tests, the court must be careful to address the idea and expression dichotomy we discussed earlier. The court must instruct the jury as to 1. The non-protectable elements of the plaintiff's work, and 2. The appropriate standards such as are they virtually identical or substantially similar, and 3. That the jury may consider the work as a whole. That is black letter law. If you want a good case on this, check out Apple Computers versus Microsoft Corporation reported at 35 F. 3rd 1435 from 1994 in the Ninth Circuit. This is an overview, then, of copyright law. And let's now move from the parking structure to the concert and start exploring some of these principles in the realm of music. You are there, but before the band plays their music and start the concert, there is music playing in the stadium. The standard rock anthems, songs from Journey, Guns N' Roses, Twisted Sister, you get the point. What are the copyright legal principles at play here? How does the venue get to play those bands' music for everyone to listen to? How do they get to publicly perform music of others? This gets us to one of those exclusive rights we looked at earlier, the public performance right. Remember, the copyright owner possesses the exclusive right to control the public performance of his or her musical composition and sound recording. But are there statutory limits to just how exclusive this right is? Let's explore. No doubt you've heard of some of the performing rights organizations. ASCAP and BMI are the two most well-known you may have heard of. These performing rights organizations function as an intermediary between public venues and creators. So, the performance right in this context refers to those who license compositions and sound recordings to perform those licensed works in return for royalties paid to copyright owners. To perform or display a work publicly means this: to perform or display it at a place open to the public, or at any place where a substantial number of persons outside of a normal circle of a family and its social acquaintances is gathered. This means that if a song is performed in a public place, then the exclusive right must be accounted for to avoid being in a position of copyright infringement. Let's pause on this public versus private distinction. You play your favorite Christmas music at home over the holidays with the family over. That is a private gathering, and you are not infringing the right by playing your playlist. So jingle bells away at home. But when you go down to Starbucks to get your coffee, or go to work out at the gym, or you go to a hotel lobby and the establishments are playing the music, that touches the public performance, right? And so they need to have a license to play the music publicly. There are millions of songs, so your next question is, how does this work practically? This is where ASCAP and BMI and other performing rights organizations come in. These organizations sign up the artists, and then the organizations license public venues with blanket licenses to play from the catalog of music they have rights to. Let's get into the nitty-gritty a bit to understand the flow of music and money here. The given performing rights organization signs up a variety of artists and their music. They then license businesses, and the fees collected by the organization are distributed to the artists as royalties after taking a roughly 10% fee for operating expenses. How do they know how much to send Madonna and how much to send Guns N' Roses? They use technology, databases of playlists and popularity, sampling analysis of radio stations, confirmed broadcast cue sheets, and other third-party data sources to estimate what percentage of the total catalog belongs to what artist. It's a Herculean task. Take ASCAP. It has 20 million songs in its catalog. Just imagine the accounting complexity in apportioning that gross revenue to the 20 million individual songs. The internal formula is itself proprietary, and money is paid out quarterly or yearly. How do they decide how much to charge the business? It is a function of the size of the business, location, number of guests, and other factors like this. But I bought the DVD or CD of the music, the small hotel operator says. Why can't I play the disc I bought? Because buying the DVD or downloading the song does not transfer that exclusive right to publicly perform the music on the DVD. And let's end on a good practice pointer for your small business clients. These organizations have employees who go to cities and just go store by store, bar by bar to see if music is being played, and when they find one playing music without a license, they get a nasty lawyer letter with serious potential financial exposure now on the line. So the advice you give to your small clients is this: if they are operating any kind of business open to the public, or if it is a non-public business, but with a greater than normal circle of just friends and family around, then a public performance business license is needed from one of the performing rights organizations to play their specific catalog. One final caveat: use only the catalog of the organization you signed up with to be safe, or sign up with all of them. You do not want to sign up with one, play your Apple Music playlist, and find yourself playing music you did not license. Where did this complex structure come from? It began with some antitrust rulings in the 1940s that helped create this modern structure. Back then, the United States entered into the consent decrees with ASCAP and BMI to remedy competitive concerns from the exclusive and blanket licensing of individual copyrights. The core of the antitrust decrees is to encourage competition between ASCAP, BMI, and other organizations for members and music users. These antitrust decrees prohibit exclusive licensing and protect members to license directly if they wish. These decrees also get reviewed in courts sometimes to address modern technology changes. There is also a thorny question of whether members can issue partial licenses to the organizations, so that certain types of users could be denied the right to secure a blanket license. This has come up particularly in recent years in the context of politics, where political candidates appear at a venue to do a campaign rally. The venue, of course, has their license, and the candidate then wants to play a particular song as their theme song. The artist then gets upset that candidate X is associating heavily with their song. This has repeated for decades. You may remember, if you are old enough, President Reagan's 1984 campaign, where he played Born in the USA by Bruce Springsteen at campaign rallies. The boss did not like it and wanted it to stop. Rinse repeat in modern times with President Trump and certain artists. Currently, discrimination within blanket licenses is prohibited, but it is an issue on the table. And if you want to learn more about this, we have a 1-hour Curious Lawyer program on this very topic. It's called You Can't Always Get What You Want: Political Campaigns and the Public Performance Right. Go check it out if you want a deep dive into the fascinating history of this issue. But we will also quickly sidebar here on a recent case raising this issue of music in venues under their blanket licenses. This is a 2020 case of Neil Young versus Donald Trump. This case centered around President Trump's use of Neil Young's song "Rocking in the Free World" at campaign rallies. Neil Young did not like the use, but President Trump had the benefit of a blanket license from the venue and one for the campaign organization. Nonetheless, Neil Young sued. You can see here a screenshot of the cover page of the complaint filed in the Southern District of New York. Let's talk about the case briefly on this little sidebar. Let's do a quick look at the case and what happened. The Trump campaign was using "Rocking in the Free World" and "Devil's Sidewalk" over Neil Young's objection. In 2016, Neil Young complained and Trump stopped. Notably, Bernie Sanders used the song without objection. But in 2020, the Trump campaign started using the songs again. Trump certainly had a political campaign license. Apparently, though, Young had ASCAP remove certain of his songs from the blanket political license. This gets at the anti-discrimination principle we discussed. Neil Young sued and claimed, quote, "Plaintiff in good conscience cannot allow his music to be used as a theme song for a divisive, un-American campaign of ignorance and hate," end quote. You see then that the case raised a collision between two ideas. 1. The antitrust decrees require the performing rights organizations to offer music licenses on equivalent terms and ban the licensing groups from partially withdrawing rights to circumvent the decrees. And 2, the organizations also contend that they can remove particular songs to prevent erosion of the economic value of a song's copyright. Here is what the general counsel of the organization at issue, BMI, said, quote, "BMI does not remove a song from the license in order to achieve higher rates or for any reason other than that the rights holders believe the association of their song with a campaign is an implied endorsement and diminishes the value of that work," end quote. Given the law we have looked at, these types of limited withdrawals of songs from certain licenses raise real issues. And what happened with the lawsuit? Neil Young dismissed it with prejudice voluntarily after several months. That gives you insight into this issue on the scope of licensing practices in venues under these blanket licenses. So now let's get back to your concert. At last, the singer or band takes the stage. You are excited. You, of course, take out your phone and start recording. We will get back to that in a little while. The singer, the band, they play their music. Then they play a cover song of another artist. Think Nina Simone playing Bob Marley's "No Woman, No Cry" live. A truly incredible rendition if you have not heard it, by the way. And now go listen to it and send some royalties back. I remember once at a Madonna concert she played "American Pie," an original song of Don McLean. This raises the question, does she need a license to play it? The answer is no, because the venue has a license to play that song. A license for public performance of music, which we just addressed. And when Madonna records her version and later releases it, how does that work? This gets us to our next segment on compulsory mechanical license laws. What is the compulsory mechanical license? The United States Copyright Act allows anyone to re-record and make a cover version of any song that has been commercially released. This is part of the copyright quid pro quo that attaches and delimits the scope of this particular exclusive right to the original creator. That exclusive right, in other words, has a limit. That cover artist then pays a set royalty based upon a legally set framework for royalties created by Copyright Office. Here's what the U.S. Copyright Code says. Quote, in the case of non-dramatic musical works, the exclusive rights provided by clauses 1 and 3 of Section 106 to make and to distribute phonorecords of such works are subject to compulsory licensing under the conditions specified by this section. End quote. You can find this in Title 17, Section 115. So how do you do it? How did Madonna make her cover of American Pie? By the way, another plug now for Madonna. I think her cover is way cool. Here are the steps the cover artist must go through. First, send a notice of intent 30 days before sale of the cover version. Second, the cover artist must send royalty payments monthly to the original copyright holder. Incredibly, sometimes the original copyright holder can make more from a cover version than they did on their original release, depending upon the cover version and its popularity. Third, the cover artist must file an annual statement listing the total yearly sales. This must be certified by a CPA also. That is the process. Any one of you budding musicians can thus make your great cover version and release it. So as we have seen, the act of making music and releasing it publicly creates a mandatory quid pro quo to other artists who can cover your released song. The copyright monopoly in this sense is limited by this compulsory license structure. But the question that arises is, what is the scope of this compulsory license? Here is what the United States Copyright Code says. A compulsory license includes the privilege of making a musical arrangement of the work to the extent necessary to conform it to the style or manner of interpretation of the performance involved. But the arrangement shall not change the basic melody or fundamental character of the work, and shall not be subject to protection as a derivative work under this title, except with the express consent of the copyright owner. This comes from Title 17, Section 115A2. But there are some important caveats that we need to explore. First, this is not a right to bootleg original recordings. That is, you cannot just copy Guns N' Roses' song Sweet Child of Mine, recording onto a disc and claim it as a cover when it is a total copy of their version. Here is a case on this issue. Quote, bootleg tapes, which are reproductions of another's recordings and which are marketed under different label, are not protected by Copyright Act. End quote. This is from the case of United States versus Schultz, reported at 482 F. 2nd 1179 from the Sixth Circuit in 1973. Here is the second caveat and practice pointer for your clients. The compulsory license provision does not confer a right to synchronize musical compositions with visual images and to publish and display lyrics from compositions owned and controlled by others, because Section 115 authorizes one to make phonorecords and nothing more. That is, audiovisual devices are specifically excluded. This comes from the case of Leadsinger Incorporated versus BMG Music Publishing at 429 F. Sup. 2nd page 1190 from the Central District of California in 2005. It was affirmed by the Ninth Circuit at 512 F. 3rd 522 in 2008. Let me double-click quickly for you. Madonna can make the cover of American Pie, but she cannot put it into an audio-visual work absent further licensing from Don McLean. Or when Guns N' Roses made their fantastic cover of Knocking on Heaven's Door under this scheme. There I go again, plugging Guns N' Roses this time. But to make a music video of the cover song, Guns N' Roses needed further rights from Bob Dylan. Given those plugs, you all clearly know that I am a child of the 1980s at this point. But this is about you, so let us now return to you at your concert. Here's a pointer for you. There is no right to record an audiovisual work of the concert. Your phone is making a music video and you cannot do it. You can look at the case of ABKCO Music Incorporated versus Sagan, case number 20-3816 from the Second Circuit on October 6th, 2022 for these general principles. We will talk more about this at the end of the program, but for now know that technically your recording is an act of infringement. So let's peel the onion a bit more to understand this right, to make a cover that does not alter the fundamental character of the work. The devil is in the details. Is it a cover? Or is it a new work that copies parts of and echoes the original, but is not a cover? The line, it turns out, can be murky. Recall the Copyright Act that says, quote, "A compulsory license includes the privilege of making a musical arrangement of the work to the extent necessary to conform it to the style or manner of interpretation of the performance involved. But the arrangement shall not change the basic melody or fundamental character of the work, and shall not be subject to protection as a derivative work under this title, except with the express consent of the copyright owner." End quote. Thus, if a fundamental change occurs, then there can be no taking advantage of the compulsory license scheme, and the work will be a derivative work, and thus an infringement of that right. Remember the exclusive rights that belong to a copyright owner? Include the right to make derivative works, and there is no compulsory licensing scheme that allows anyone to make a derivative work of an author's creation. This is why fan fiction is outside any of these realms. Here is what Congress said when passing these laws. The legislative history provides that the provision, quote, "is intended to recognize the practical need for a limited privilege to make arrangements of music being used under a compulsory license, but without allowing the music to be perverted, distorted, or travestied." End quote. You can look up the legislative history in full at the citation there on your screen. But the point is key. No distortion, no fundamental character change. Of course, as with all we do as lawyers, the devil is in the details. Now we will consider when a work is fundamentally changed. Certain cases are easy. Madonna's American Pie cover or Guns N' Roses Knocking on Heaven's Door are not fundamental changes, even if they do the song in more upbeat tempos or through a hard rock prism. But what happens in harder cases? This allows us to look at one case. This is the case of TV Tunes Incorporated versus DM Records Incorporated from 2007 in the U.S. District Court in the Southern District of New York from 2007 reported at 2007 Lexus 74822. In this case, the plaintiff argued that the work was not a cover and was really a derivative and hence infringing work. The defendant argued it was a cover. Each had experts, and the experts disagreed at summary judgment on that Section 115 fundamental character question. Because they disagreed, the court ruled that it required a jury trial to assess the competing experts. For those of you litigators, this is a tough spot to have your client in when paid experts do this. So the safe practice pointer is to follow the original and do a cover without tweaking the melody, lyrics, and other aspects of the song. Stray from that, and you may find yourself in trouble. But the plot thickens as we consider what happens to true covers that are creative and comply with the scheme, but then themselves are copied. This brings us to Sir Mix-a-Lot's 1992 famous song, "Baby Got Back." You all remember it, I am sure, from the dance clubs you were in back then. Well, in 2005, an artist named Jonathan Coulton did a funny cover arrangement with same lyrics and a new melody with a folk-style acoustic arrangement. Coulton applied, got a proper Section 115 license, so he was safe. Then Fox's show Glee made a version just like Coulton's and did not pay him. Why? Section 115 states that the new work, here Coulton's creation, is not a derivative work subject to copyright protection unless the original copyright owner consents. This means that the cover gets no new copyright protection even for the new otherwise copyrightable elements that may exist. Unfair loophole. He certainly thought so. The matter was never litigated, but it has created lots of academic and policy debate about the limits of Section 115 and the need for reform to protect cover artists who themselves innovate within the spirit of copyright law. So stay tuned. So let's get back to your awesome concert. The band is performing and use audio-visual displays of art and graphics. Think the amazing U2 show at the Sphere in Vegas if you were fortunate to see that show. Or think of the rock band Green Day, which has actually had the issue of their art be litigated within copyright law. This brings us to our segment on Green Day and fair use in copyright law. Basically, as we will discuss shortly, there was an original piece of art which you see at the top of the screen. In the Green Day concert, there was an audio-visual video that played on screen to one of their songs, and the art was used and modified. You can see the Green Day concert part in the picture on the bottom. You can see it is modified and altered, but was certainly using the original work. They were sued, and the question the band raised was whether their use was fair use under United States copyright law. This now requires us to explore fair use and its test. For fair use, we truly need to go back to the beginning. The founding of the Republic and the Constitution and its discussion of copyright and its purpose. Here is what the Copyright Clause of the Constitution states as the goal of copyright, quote, to promote the progress of science and useful arts, end quote. This is in Article 1, Section 8, Clause 8. Now, there is no textual provision for fair use expressly articulated in the Constitution or by Congress at the Republic's founding, but it was part of the common law from England that had litigated these issues. And this brings us back to Justice Story, who again makes an appearance in this program on foundational copyright precepts. He said as follows in a seminal famous case, "To assess fair use, courts must, quote, look to the nature and objects of the selections made, the quantity and value of the materials used, and the degree in which the use may prejudice the sale, or diminish the profits, or supersede the objects of the original work." End quote. That is from the case of Folsom versus Marsh, reported at 9, F. Case 342 from the District Court in Massachusetts in 1841. That conception of fair use as a doctrine that allows breathing room so new innovators may promote the progress of the useful arts has been foundational to our law. And he appears again. Here's another statement he made that is also a poll star. Quote, "In truth, in literature, in science, and in art, there are and can be few, if any, things, which in an abstract sense are strictly new and original throughout. Every book in literature, science, and art borrows and must necessarily borrow, and use much which was well known and used before." End quote. This is from the case of Emerson versus Davies, reported at 8F. Case 615 at page 619, again from Massachusetts, this time in 1845. The question that is always raised then is this. Given the nature of creative efforts is to borrow and adapt from prior ideas, how much is too much to take? How much is fair? As a doctrine, the history of fair use was in the common law of the courts until 1976. Literally, it was not codified until 1976 as a formal legal right by way of positive law. And when it was codified, it followed heavily Justice Stories and the subsequent 2 centuries of development. Here is what Congress enacted in 1976 for the Copyright Act that went into effect in 1978. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include the following. 1. The purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. 4. The effect of the use upon the potential market for or value of the copyrighted work. Those 4 factors frame our analysis today and are found in Section 107 of the Copyright Act in Title 17. How does this play out in litigation in the real world? First, fair use is an affirmative defense to a copyright infringement claim. This is important because it puts a new creator on the defense out of the gate, having to defend a claim of infringement with all the costs and risks that entails. Let us now do a quick copyright recap that is required to contextualize fair use assertions. Remember, copyright gives the author of an original work certain exclusive rights with respect to that work. 1. Reproduction right. 2. To make derivatives. 3. The right to make public distribution of copies. 4. The public performance of works such as songs, movies, plays, etc. 5. The right to a public display. And 6. The right to public performance of sound recordings. And of course, violating those exclusive rights is an act of copyright infringement. Tripping this line in certain cases can trigger the defendant's fair use affirmative defense, which posits any borrowing or use is acceptable under the law, because the taking was a fair use one, and so cannot be actionable. In other words, it's lawful borrowing or copying in effect. And as we have seen, these fair use factors as an affirmative defense are codified in the law now. This is the law, then, Green Day was looking to in its case that we are about to explore. 1. The purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for or value of the copyrighted work. Given the history of fair use and the Constitution, the question we now confront is whether Green Day's modified art was a fair use or an infringement. Let's take a look now. Again, don't forget the two works we are considering. The first is The Art of the Plaintiff, a poster put up and known as the Scream poster. And then there is Green Day's audiovisual work that accompanied a song where the poster appeared during parts of the video in modified form you can see here. So let's get into the facts of the case. Defendant Staub created for the Green Day song, called East Jesus Nowhere, the allegedly infringing work, an approximately 4-minute long video. The video depicts a brick alleyway covered in graffiti. The graffiti includes at least 3 images of Jesus Christ, which are defaced over the course of the video. Throughout the video, the center of the frame is dominated by an unchanging but modified Scream icon, a work of Plaintiff Seltzer. Staub used the photograph he had taken of the image at Sunset and Gardner in Los Angeles. He cut out the image of the Scream icon and modified it by adding a large red spray-painted cross over the middle of the screaming face. He also changed the contrast and color and added black streaks running down the right side of the face. Staub's image further differs from Scream icon because Staub's original photograph was of a weathered, slightly defaced and torn poster. However, the Scream icon is nonetheless clearly identifiable in the middle of the screen throughout the video. So what do you think on those 4 factors? Hold your thoughts and let us now see what the Ninth Circuit held. Analyzing the 4 factors, here's what the Ninth Circuit ruled. On factor 1, the court held that use of photo was transformative because it was not simply a reproduction, but was put into a video with other elements, where the video was about religion and Christianity, and the original art had nothing to do with religion since it was an anguished scream face. On factor 2, the court found that the Scream icon is creative, so gets protection. On factor 3, the court held that the work not meaningful divisible, and this factor does not harm a defendant, even if they took all of it, if the whole was necessary for the new work. And on factor 4, the court found that the use of Scream icon was only incidentally commercial. The band never used it to market the concert or merchandise or otherwise monetize it. Thus, Green Day won and its new use was deemed a fair use of the original. Here, plaintiff also brought a trademark claim, but the court also rejected that claim because the plaintiff had not used the image as a trademark with any goods or services. This sometimes comes up in copyright cases where trademark claims are also brought. But to be a trademark, the art or logo must have been used in commerce to denote a product or service. Here it was just art and was not used as a standalone trademark, so the plaintiff lost that claim also. And here is a scary point. In the trial court, Green Day got a $200,000 fee award for winning against the original author. But this was reversed on appeal because the artist's claim was not objectively unreasonable to sue and think that there was no fair use. Here is what the Ninth Circuit ruled. Quote, "This was a close and difficult case. We conclude that Seltzer's work was transformed by Green Day's use. But that transformation was far from obvious given Green Day's only slight alterations to the original." End quote. The plaintiff artist got lucky to escape that fee award, but it hung over him for some time, and this is one of the risks of copyright litigation given the uncertainty of fair use. You can read the whole case at 725 F. 3rd at page 1181. So you loved the concert, you got to your car, no damage thankfully to the car, and you head home. What do you do next? Well, of course, you go to your social media account to share with your friends and the world your awesome concert experience. And you do that by taking your recorded video and uploading it. But what does this trigger in copyright law? Recall, the first exclusive right we addressed was the right to reproduce a work that belongs to the copyright owner. This is triggered then by a phone recording of the musical composition and sound recording. The act of recording the music reproduces it on your phone and thereby infringes the copyright. So strike one for you. But no, you do not stop there. You then post it online. The act of posting online recopies it to the social media platform servers and is another act of infringement of the reproduction, right? Strike two. This then lets us loop back to contract law, because this will also violate the terms and conditions of the platform that expressly require you not to infringe copyright. So the end of your concert night includes both a contract and copyright intersection for your experience. This brings us to the end of the concert and this continuing education program. There are several conclusions that flow from this curious lawyer journey we have been on. Of course, the first is get out to a rock concert and have fun. The second is the obvious. After your fun, take an Uber home if you have been drinking. The last thing you want is to have to watch one of our programs on alcohol and the law, and you certainly do not want a DUI. But when you are there at your next concert, you will appreciate, I hope, how copyright law so heavily mediates that fun experience. Of course, contract law does too. So let's do a quick recap of what we have learned today on both fronts, and you will be ready to get to your next concert. We had a chance today to explore some contract and copyright law principles within the realm of our Curious Lawyer program on what it means for you when you go to a concert in terms of how that experience intersects with the governing legal regimes. Of course, there is more law affecting us than what we have covered here today, such as antitrust issues I alluded to. But this is the core of what matters for you as a concert goer when you are thinking about copyright. Let's start by briefly recapping some of the contract issues we looked at. We considered the form contracts that are on the tickets we get at parking kiosks or as posted at the point of entry. In some jurisdictions, those create a bailment relationship, which is advantageous to a plaintiff. But in some jurisdictions, it will not create a bailment relationship. However, even then, negligence law applies only now. The burden is on the plaintiff rather than the defendant in the event of a situation that occurs with the car or a loss. We looked also at disclaimers of liability and their enforceability, specifically a California case that limits the scope of such disclaimers, allowing you still to find refuge in negligence law. We also saw the difficulty for a plaintiff in a very tragic case of rape, where the negligence of the defendant created too many questions with respect to the element of the negligence tort, thereby saving the defendant from liability. And on the copyright front, we looked at an overview of copyright law to understand what is the subject matter of copyright, what are the exclusive rights that belong to a copyright holder, and how the infringement test works. We also looked at the difference between ideas and expression in terms of what is copyrightable. We then walked through the public performance right and how the performing rights organizations operate to secure monetary remuneration for the underlying artist by issuing blanket licenses to businesses. We did a quick sidebar on political campaigns and the anti-discrimination principle that sits beneath, and how difficult it is for artists to try to stop particular politicians from playing particular songs given the antitrust decrees. We looked at the compulsory licensing scheme that exists for those who want to make cover songs of already released music. There is a regime that one must comply with in order to make and publish the cover song, but the original artist is subject to this compulsory license if that scheme is complied with. But we also looked at what is a song that fundamentally changes the work and becomes an infringing derivative work. We were able to also assess some copyright fair use principles by looking at the Green Day case and the 4 factors that our courts used to assess whether a defendant's use of a plaintiff's work is fair use or infringing. And of course, we took a look at the reproduction and how that is easily violated in this modern era with phones recording songs at concerts. Fundamentally, what we have done in this Curious Lawyer program, I hope, is educate you about some contract and copyright law principles that attach when you attend a concert. So check out our other Curious Lawyer programs. And now, get going to your next concert. Enjoy it, rock out, and do it in a legally safe and fun way. Thank you for watching today.